I'm going to talk about possible consequences for military personnel convicted of drink driving offences. I've previously produced videos relating to drink driving, and I've also previously produced videos relating to major AGAI 67 action as a result of convictions in the civilian courts. So today I want to specifically address possible consequences for military personnel who have been convicted at the magistrates' courts of offences relating to driving under the influence. So assuming that the individual has either pleaded guilty or has been found guilty after trial, the matter will proceed to sentencing. Obviously, if the individual has been acquitted, that's fine. That's the end of the sentencing process in the magistrates' court. It would still be possible for major AGAI 67 action to be instigated even following a conviction, but I don't want to talk about that. I want to talk about where an individual has either pleaded guilty or been found guilty by a magistrates' court of driving under the influence. So to look first at the Magistrates' Court sentencing guidance. So this is the sentence that may be passed at the Magistrates' Court for the civilian aspect, and then look at the major AGAI after that. The important point to note is this: under the sentencing guidelines, the level of sentence will depend upon the amount of intoxication. So the legal limit is 35 micrograms of alcohol in 100 millilitres of breath. Anything above that is an offence. In reality, the police do not prosecute if the lower reading is less than 40. If it's between 40 and 50, then there has to be the option for a blood sample to be given, a blood test to be taken to determine whether or not the individual is actually over the limit, and the reason for that is that blood is more accurate than breath. So the legal limit is 35, but in reality the sentence would only be passed, or matter would only be prosecuted, if the individual had provided a lower reading of over 40. So to consider first what the Magistrates' Court might impose by way of sentence. So to look at the Sentencing Guidelines Council, there are 4 limits, 4 levels. The levels are 36 micrograms of alcohol through to 59, 60 through to 89, 90 to 119, and then 120 through to 150 and above. For levels of alcohol between 36 and 59, although as I said in reality it's going to be 40 and 59, the starting point is a band C fine, and the range is a band B fine to a band C fine, with a disqualification period of 12 to 16 months. However, if this is the second disqualification offence in 10 years, then the disqualification period is 36 to 40 months. So the range is a band B fine to a band C fine. So to explain fines, the level of fine is dependent upon the individual's weekly income. A band A fine is 50% of relevant weekly income. A band B fine is 100% of relevant weekly income. A band C fine is 150% of relevant weekly income. A band D fine is 250% of relevant weekly income. A band E fine is 400% of relevant weekly income. And the band F fine is 600% of relevant weekly income. So to look at the next level, an individual who provides a lower breath sample of 60 to 89 micrograms of alcohol and 100 millilitres of breath, the starting point will be a band C fine, and the sentencing disqualification will be between 17 and 22 months, unless this is the second disqualification within 10 years, in which case the disqualification period will be 36 to 46 months. To consider the next level up, if the lower breath reading is between 90 micrograms and 119 micrograms of alcohol in 100 millilitres of breath, the starting point then is a medium level community order, and the disqualification period is 23 to 28 months, unless it's the second disqualification within 10 years, in which case it's 36 to 52 months. And finally, to consider the highest level, this is effectively anything over 120 micrograms of alcohol in 100 millilitres of breath. The starting point is 12 weeks custody. The disqualification period is 29 to 36 months, although the court may consider extending if imposing immediate custody. And if this is the second offence within 10 years, then the disqualification period is between 36 and 60 months. I should mention briefly the drink drivers rehabilitation course. So for an individual on the day of sentencing, the Magistrates Court will provide them with the opportunity, if they wish, to take the drink drivers rehabilitation course. It's very important, if they want to do this, that the defendant opts for this option on the day. The drink drivers rehabilitation course provides the opportunity for a period of disqualification to be reduced, providing that the drink drivers rehabilitation course is taken in full within the prescribed period. So it is a useful option for regaining a driving licence at an earlier date for individuals if they elect to take the drink drivers rehabilitation course. But it is important that they ask to do that and they accept the offer to do that on the day. So I said that this video concerns military personnel in the Major AGAI 67 system following conviction. So the conviction, the failing of the service test, is the conviction at the Magistrates Court for driving under the influence. Now, the seriousness for Major AGAI 67 will depend on a number of factors. Major AGAI 67 does provide that driving under the influence can result in a termination of service in some instances. So to consider those instances, a commanding officer is to consider termination of service where either A, the conviction was obtained while serving a previous driving ban, or B, if there was any dangerous driving that endangered life whilst driving under the influence, or C, leaving the scene of an accident, or D, having a previous unspent conviction for driving under the influence, or E, where the offender is an officer. Another point to address is the difficulty for personnel within the Royal Military Police, because a conviction for drink driving under AGAI 67 renders their position within that particular corps untenable. It means that the option may be available for them to transfer to a different corps, but it does mean that remaining within the Royal Military Police is going to be very difficult and nigh impossible. So for individuals not in the Royal Military Police and who don't come within those A to E aggravating factors, such as holding the Queen's Commission, or such as dangerous driving that endangers life, or such as having a previous unspent conviction, the level of severity at Major AGAI 67 will depend in part on the individual's rank. So to consider driving under the influence, it's classed as other misconduct under Table 2A of Major AGAI 67, and the sanction is dependent upon the individual's rank. So if an officer is retained, so provided an officer is not required to resign their commission as a result of this, because that was category E of the more aggravating factors, an officer convicted of driving under the influence is likely to lose all of their seniority. If an individual is on an FTRS engagement, full-time reserve service engagement, it is likely that that will result in termination of their service. And the recommendation under Major AGAI 67 for other ranks is that there be a reduction in rank. So in summary, for military personnel convicted at the Magistrates' Court of driving under the influence, the level of sentence will depend upon how high the lower reading of breath was that they provided, or blood if it was between 40 and 50. So it will result in the disqualification. The minimum disqualification is 12 months, but the level of disqualification thereafter depends upon two factors. It depends upon the level of intoxication, and it also depends whether or not they have had a previous conviction within the past 10 years for a similar offence. Having then received the conviction, they are deemed to have failed the service test, and that instigates Major AGAI 67 action. Under Major AGAI 67 there are aggravating factors, but assuming none of those aggravating factors apply, and assuming the individual is not in the Royal Military Police, then if they are an officer and are to be retained, it's likely they will lose their seniority. If they're on a full-time reserve service engagement, it's likely that that will result in termination of service. And if they are other ranks, it will result in a reduction in rank, unless of course they're a private soldier. If they're a private soldier, it will mean marking time in their existing rank.